All right, now let's talk about the jury instructions. All right. We're first, let's do the first one.
Mr. Shapiro is going to do the jury instructions.
Well, I actually anticipated the state was going to make some arguments about their modifications or special instructions.
Understood. All right. So first, the first one, we've got the prior violent felony aggravator aspect with that sentence. My understanding, okay, I've looked at James, so other than that, anything else to add, Mr. Stone?
No, just for that particular aggravator, just that, Your Honor. James versus State approved it, I think, and it's a statement of the law. That's what the law is, it's not covered in the standard instructions. It's something that the jury needs to understand. So it's not covered in the standard instructions. It is clearly an accurate statement of what the law is. And what I put in, the addition that I put into the standard instructions is literally a quote from the James case.
Okay. No, I noted. It's specifically in there. All right, and your indication is as to why it should be is because of the fact, why?
Well, the reason is because it's not in the standard instructions. As a matter of fact, that case, which was a Seminole County case, and it involved Judge Dickey. Judge Dickey gave it. In this case, I'm reading from head note number 7. In this case, the trial court instructed the jury pursuant to the state's request, and then so on. And so it's obviously something that's approved by the Supreme Court. They found no error. As I said a moment ago, or argued a moment ago, it's not contained in the standard instructions, and it's not something intuitive that the jury would understand. So I think it's important the jury understand that.
All right. Mr. Shapiro?
Judge, our objections actually don't apply with this argument that the state has.
I'm sorry?
Our objections to the special and standard or special instructions and the modifications that the state wants don't have anything to do with their first argument. So I really don't have an objection based on the case that I've read.
Okay.
James, I have no issue.
All right, you could have said that in the beginning.
Right. I'm sorry, I didn't want to interrupt you.
All right, okay.
But the second two is where we have objections.
All right, so the first one, the court, based upon the case law, it's completely on point, so the court would allow it.
We're in complete agreement.
All right, okay. Well, then you're objecting to the second two.
Judge, yes, the state appears to want to include a jury instruction regarding lingering or residual doubt. Now, the state's case that they provided.
Understood. Let me ask the state. Mr. Stone, why should I give the aspect of the lingering doubt instruction?
Because, once again, that's what the law is. It's not contained in the standard instructions. And we don't know what the jury is thinking. The jury may well, during the guilt phase, have said, well, we heard the argument. We know what reasonable doubt is. The court informed us what reasonable doubt is not. It's not a possible doubt or a forced or a speculative or imaginary doubt. And they may, we don't know if they went back there and deliberated. Well, you know something? We kind of have those doubts where it's possible, we're forcing ourselves, but we're going to follow the instructions. That's not a reasonable doubt, so we're going to find the defendant guilty. But we don't know if they had those kind of doubts. So it doesn't hurt to inform them that if they're thinking, well, it's possible that he didn't commit this crime, or we can speculate, and some of them may be thinking that.
Okay, well,
it's important for them to understand that that's not...
Let me ask you this, all right? Because they've already had the guilt phase, and they've already found him guilty.
Correct.
All right? And if neither side, if the defense is not even arguing lingering doubt in regards to the circumstance, that there may be residual or lingering doubt about the defendant's guilt, we've already passed that phase. Why is it that the court should bring that up? How is that in something that should be added towards a special instruction? I mean, in looking at it, I realize what you're stating, but there isn't anything, I was trying to find if there's anything specifically instructing the jury on this point.
No, it's not in the standard instructions, and that's the reason why it's important. It's just simply a statement of the law. I don't know how it can hurt to inform the jury that that is not a mitigating circumstance. The court's going to inform them that I can't think of it verbatim, but I can look at it and tell you.
However, a mitigating circumstance does not include any residual or lingering doubt you may have about the defendant's
No,
guilt.
I'm not talking about that. I'm talking about the court's going to instruct the jury that they can consider any aspect of the case or the defendant's character or the defendant's background. Well, any aspect of the case. That may well, we don't know, but it may well include some type of possible or lingering doubt that they have. Once again, Your Honor, I don't see how it can hurt to just simply inform the jury what the law is, that is not a mitigating circumstance. It can't hurt.
Response.
The response would be the same reason you gave, that you didn't want to instruct the jury prior to going forward with the victim impact. That was also a statement of the law. We had requested it, you had denied it. That's fine. Every case they have to prove beyond a reasonable doubt. So if the Supreme Court thought that it was important enough to include in their standard instructions, they certainly didn't include it, because I think it could apply to every single case, and they just didn't decline to include it. Because we're not arguing it, it's not possible, it's not allowed to be argued. And the state's case that they provided has to do with the fact that a judge didn't address lingering doubt in a sentencing order. It has nothing to do with jury instructions or special jury instructions, and therefore we would argue that it's not really relevant in the case we're talking about. It's not to say that what the state's providing isn't an accurate statement of the law, but the case that's provided has nothing to do with jury instructions and whether it would be appropriate to have that special instruction in the case. This is precisely why we didn't have any objection to the first argument, because they have a case directly on point regarding special instructions, and this case doesn't have anything to do with special instructions.
Yeah, the court's going to deny I'm not going to allow the second one. All right, where it indicates, however, a mitigating circumstance does not include any residual or lingering doubt you may have about the defendant's guilt. That one the court's not going to permit. Well, I do believe it may be an accurate statement of the law based upon what's indicated in Reynolds versus State. I don't think it rises to the standard for a special jury instruction. All right, so let's talk about the next one, which is the no significant history of prior criminal activity, the mitigating circumstance, the aspect where evidence being substituted for the word conviction.
Well, Your Honor, and that instruction, actually, if you read the italics part of it right above that, the instruction actually contemplates evidence. Now, the case was clear that any rebuttal evidence doesn't have to result in a crime. I'm just simply modifying the instruction to remove the word conviction and put in the word evidence, and right above it, the instructions to the court actually uses the word evidence in rebuttal. And that's just simply to rebut the mitigating factor of no prior significant criminal history.
All right, so let me ask you, Mr. Shapiro, your response, because based upon reading the case law, it specifically indicates that it could be evidence rather than convictions.
True, I understand that, Judge, and what's important here, it's sort of like our argument for the last issue that we went over. The case has to do with, at least the case that was provided by the state, has to do with what are allowable arguments. We're not disputing the fact that the state can come back and rebut any evidence of no significant history with arrest evidence. That's not our objection. Our objection is a modification to the standard instructions, which this case doesn't cover. There's no issue whatsoever with them making the argument. The question is whether modifying, it's not even a special instruction. In this case, they want to actually change the standard instructions, and there's just no authority that supports changing the instructions. It has nothing to do with the arguments they can make, but we would just object to the standard instruction being modified in this way, because we think it departs from the standard instructions in a way that is not necessarily supported by case law that allows that sort of modification in this instance, Judge.
And Your Honor, one brief point. The way that the standard instruction is now worded by use of conviction is misleading in this case. If the court doesn't remove the word conviction and put in the word evidence, then the jury's being misled as far as what is proper rebuttal. They may go back there and say, well, there are no convictions, so we're not going to count it as rebuttal.
Well, I think, and this is how the court's going to handle it. The first part of evidence of theft is not an aggravating factor to be considered in determining the penalty to be imposed on the defendant. Because the first portion is actually, and let me look it up again, it's supposed to be conviction of theft and conviction, if I remember correctly. Let me just look, one moment. Issue that the court has on the way it's phrased. The first portion, it would indicate the conviction of theft, which that should, the court is definitely indicating remaining the same. It would be conviction of theft. Is not an, one second, is not an aggravating factor to be considered in determining the penalty be imposed on the defendant. For rebuttal, there is, once a defendant claims according to the case law that this mitigating circumstance is applicable, the state can rebut the claim with direct evidence of criminal activity. So when it's indicating a conviction of that crime may be considered by the jury in determining whether the defendant has a significant history of prior criminal activity, I may reserve on that. I'm going to do a little bit more research over lunch because the court may allow for the evidence, although I'm not sure in regards to evidence of that crime may be considered by the jury in determining whether the defendant has a significant history of prior criminal activity. Or, otherwise, I'm just going to do a little bit more research on that portion because in looking at the research, it's clear from Walton, if the defense is offering that there is no significant history of prior criminal activity and that it's not simply convictions that can be used to rebut it. It's evidence of any criminal activity can be used to rebut the significant history of prior criminal activity and rebut that mitigating circumstance, which means if there's any evidence of any theft or any other crime, it could be used to rebut that mitigating factor.
I totally agree with that, Judge, insofar as, that they can use an arrest for whatever weight that the jury wants to give it.
Understood. But the first portion will definitely still be conviction. It's would I change that second word or not.
Your Honor, can I just make an observation regarding the first portion?
You may.
I think that entire paragraph under the part that's in italics, that's only in reference to if the state offers rebuttal evidence, and there's no evidence of any conviction in this case.
Yeah, but conviction of a previous crime is not an aggravating factor. The issue is, so conviction of a crime is not an aggravating factor. That's a correct statement of the law. The issue is whether evidence of other crimes or other instances can show any significant history of prior criminal activity.
Right,
so the second portion is what matters.
The point I'm trying to make is that if he was convicted of a theft, then that's something that the state can offer in rebuttal, but he was never convicted of a theft.
I understand.
In this case, there's only evidence of a theft.
I understand, Mr. Stone. I understand exactly what you're arguing. I just...
If the court wants to keep the word conviction, that's fine, but I don't think it applies in this case because he's never been convicted.
Okay. Well, what the court's looking at is as far as the jury instruction and the instance of it. So at this point, I'm going to reserve as to that second point, and we can go from there. But
Yes,
I ruled on the other two. The first one applies, the second one's out.
Your Honor, can we at some point talk, and maybe this may be the time to talk about it, the statutory mitigating circumstance of age? Because
right.
I don't think there's any evidence of that at all in this case.
Well, I
At least
haven't-
with respect to the statutory mitigating circumstance, I have a whole bunch of cases to talk about.
All right, well, first of all, let me ask, are you all indicating that you're going to argue age?
Currently, yes.
Okay. I don't know what the evidence is going to show, so what do you anticipate then otherwise that the evidence will otherwise show? Other than his birth certificate and what the doctor testified? Anything else from
Nothing
anybody else?
Judge.
Okay. Then whatever case law you want me, what's your argument, Mr. Stone? Because now's the time to argue it.
It's an indisputable historical fact that everyone is going to agree that he was 29 years of age when these crimes were committed. I have a series of cases that say, as a matter of law, that age, actually age 26, 23, do not qualify for the statutory mitigator of age. So as a matter of law, it doesn't apply. And I'll cite those cases if the court likes. I'll do it right now.
Here, give me the case law, I'll look them up during lunch.
Yes, Your Honor, I will. Washington versus State, 362 Southern 2nd, 658. Florida Supreme Court, 1978.
Is it 368 or something?
658, 362,
Yes,
658.
Thank you.
Next one.
The next one is Mills versus State, 462 Southern 2nd, page 1075, 1985, Florida Supreme Court. And then the next one is Simmons versus State, 419 Southern 2nd, page 316, and that's 1982, Florida Supreme Court.
All right. All right, I'll take a look at that case law over lunch.
Thank you.
If there's anything that the defense finds, just email me or Vanessa, and I'll look those up as well. But in the meantime, I'm going to be looking up both sides, all
Yes,
sides.
and Judge, just so you could go ahead and review it on, I had e-filed a defendant's proposed jury instruction on mercy, which contains a memorandum of law. It provides for the court to either grant it or deny it on that, so if you could just maybe review that as well.
When
I'm
did
not
you-
wanting to put any argument that somebody said.
Nothing, if you e-filed it today, because the only
No.
thing, when did you e-file it?
It was e-filed a couple of weeks ago.
Oh, August 7th. Is that the one, August 7th? Is that what it was?
Yes,
Okay, then I can print that out and look
because
that up.
I won't need to put any argument with the memorandum there.
Okay, all right. I'll read that too as well.
Thank you, Your Honor.
You're welcome. Okay, then otherwise, we're going to be back in less than an hour. Okay?
Mr. White?